Hey, Casey or Jenny, you're the only ones here. I just want to do a quick sound video check. Can you hear me okay?
Yeah, I see you and hear you.
Okay, I just want to make sure. Go ahead.
I'm just going to rename you because it's doing the Jennifer Boston thing.
Oh, that's bizarre.
It does that for all the internal Zooms that require registration. So,
Well, maybe I do want to be Jenny for this one, though. I mean, maybe. There's that. Okay, cool. All right.
perfect. You're all set.
Okay. Thanks, Case. All right.
See you soon.
All right. Bye.
Bye.
Good morning, everyone. I want to thank everyone for being here. We'll get started in just a moment. Before I officially call the case, I want to make sure I have a court reporter with me and that she can hear me just fine.
I can hear you. I'm present.
Great. Thank you, Harriet. All right. Let's not waste time. We have a lot of matters to cover today. So I'm going to go ahead and go on the record and call proceeding number 24R-0306E. We are now on the record in this Colorado Public Utilities Commission proceeding. Good morning, everyone. My name is Alenka Hahn, and I am the administrative law judge assigned to this proceeding. Today is Tuesday, August 27th, 2024. It is now 11 o'clock a.m., the scheduled time for this hearing to begin. This matter comes before us today for a public comment hearing pursuant to decision number C24-0494 issued on July 11th, 2024. I want to welcome all of you and thank each and every one of you for being here today to provide public comments. Before I make some opening remarks, I did want to acknowledge the many thoughtful, helpful, and insightful written comments that the Commission has received in advance of this hearing. We greatly appreciate it and have strived to read through them all, but there were quite a few. Some commenters recommended that the format of this hearing be changed to an in-person hearing. And others recommended that the posture of the proceeding be altered to, or perhaps even suspended to allow interested persons more time to discuss the important issues raised and work towards consensus rules that address some of the concerns raised with the current form of the proposed changes and additions to the Commission's electric rules. I want everyone to know that we are in receipt of those suggestions. We have reviewed them and will continue to continue considering them. However, I do want to explain that because this public comment hearing was noticed in the Colorado Register as a fully remote hearing, permitting persons to appear virtually from anywhere in the state of Colorado or the country, the hearing format could not easily be changed. It was too late. Likewise, the posture of the hearing as a rulemaking couldn't be changed either because the proceeding, as I said, was noticed in the Colorado Register. But that said, these issues and suggestions will be taken into consideration and may affect the future course of this proceeding. But for now, we are set to begin discussing proposed additions to the Commission's electric rules affecting how utilities and the Commission interact with and consider impacts on significant sites within and near tribal communities. Okay, let me make some opening remarks so that we have some context about why we're here today. The purpose of this public comment hearing is to allow members of the public to provide verbal comments regarding proposed modifications to the Commission's rules governing electric utilities. This rulemaking arises most directly from two applications filed by Public Service Company of Colorado. The first was a proceeding involving in which decision numbers C22-0270 and C22-0430 were issued. That proceeding is proceeding number 21A-0096E, which approved Public Service's application for a Certificate of Public Convenience and Necessity, sometimes referred to as a CPCN, to build the Colorado Power Pathway, which is a multi-segment transmission project. The transmission route was later modified by Public Service after discussions it had with local siting authorities and representatives of the Northern Cheyenne, Northern Arapaho, and Cheyenne and Arapaho tribes. The second proceeding, proceeding number 21A-0141E, which sought approval of Public Service's Electric Resource Plan and Clean Energy Plan, which could potentially result in the erection of 7 wind turbines impacting the viewshed of the Sand Creek Massacre National Historic Site. Tribal nations, particularly the Northern Cheyenne Nation, expressed their concern and highlighted the historic and cultural significance of the Sand Creek Massacre site. Nearly contemporaneously with those two proceedings moving forward, in 2021, the Colorado General Assembly adopted Senate Bill 21-272, which required the Commission to promulgate rules considering, quote, how best to provide equity, minimize impacts, and prioritize benefits to disproportionately impacted communities and address historical inequalities, end quote. In directing the Commission to identify disproportionately impacted communities, the legislature identified tribal or indigenous populations as being disproportionately impacted, and it specifically named certain tribes. To achieve that goal, the Commission initiated proceeding number 22M-0171ALL. That's 22M-0171 all, to solicit comments and gather information to help it identify disproportionately impacted communities. That proceeding is continuing. And it's against that background and in response to those concerns raised by the Northern Cheyenne, Northern Arapaho, and Cheyenne and Arapaho tribes in the 2 public service proceedings that the Commission initiated this rulemaking to look into promulgating rules amending the Commission's electric rules. The stated purpose of this rulemaking is to clarify for electric utilities the expectations regarding the appropriate treatment of sites of significant cultural and historic importance, such as the Sand Creek Massacre National Historic Site, when utilities develop electric infrastructure. The Notice of Proposed Rulemaking, sometimes called the NOPR, was issued on July 11th, 2024 by decision number C24-0494. In addition to proposing amended rules, which were appended to that decision, and which I'll summarize shortly, the NOPR asked for feedback from stakeholders about certain issues, set a timeline for stakeholders and interested persons to submit written comments about the proposed rules, referred the matter to an administrative law judge to issue a recommended decision to the Commission, which is how the case came to me, and scheduled a public comment hearing for today, Tuesday, August 27th, 2024, commencing at 11 a.m. So I am the ALJ to whom this rulemaking was assigned based on the Commission's referral, and we are here today to hold that public comment hearing as scheduled by the Commission. All right, the proposed amendments and additions to the electric rules include numerous proposed changes. I'm going to briefly go through them so that we can kind of set the stage for where we'll be today. The proposed changes include the following. 1, additions to the definitions section, adding definitions for cultural and historic resources, significant site, and tribal nations. 2, changes to the rule governing certificates of public convenience and necessity to construct and operate a facility or extend a facility, which require applications to address any impacts to significant sites, as well as the cost associated with avoiding or mitigating those impacts. 3, to make amendments to the rule governing the only cooperative electric generation and transmission association in the state of Colorado, Tri-State Generation and Transmission Association, requiring it to seek information about potential impacts to significant sites from bidders to its RFPs, its requests for proposals, and address any impacts in both Phase 1 and Phase 2 Commission decisions. 4, to make changes to the bid evaluation and selection process requiring the Commission to address the sufficiency of a utility's treatment of historic and significant sites in the Commission's Phase 2 decisions. 5, to make changes to the rule governing requests for proposals, mandating bidders provide information on impacts to significant sites. 6, make changes to the Commission's review and approval of resource plans, that's what we call Phase 1, to assess the sufficiency of a utility's consideration of significant sites. 7, to add a requirement to electric utilities' annual reporting mandates to advise the Commission of any ongoing discussions or consultations utilities may have with tribal nations regarding impacts to significant sites. 8, the addition of a rule expressly addressing significant sites, which lays out the steps and procedures that a utility must follow to mitigate impacts to significant sites. And 9, the addition of a requirement to utilities' 10-year transmission reports, providing information about communications the utility has had with tribal nations regarding significant sites. So that's just an overview of the proposed changes to the rule. Okay, at the outset, and before we get into accepting comments about the proposed rules, I would like to state that the Commission has received a wide breadth of comments, many of which raise complex issues meriting careful and thorough consideration. Because of the breadth, the scope, the volume, and the complexity of the written comments the Commission has received thus far, I will likely need more time to process and analyze both the written comments already received and the verbal comments I'll hear today. Therefore, I'm going to forewarn you that at the conclusion of today's public comment hearing, I may continue the hearing to allow further comment and consideration. In fact, because of the importance and complexity of the issues raised, it's possible that I'll hold multiple public comment hearings over the next several months. I'd also like to emphasize that we are at the very beginning of this rulemaking process. The Notice of Proposed Rulemaking, the NOPR, was issued just over a month ago and included only proposed rules. These are by no means a final rendering of what the rules may or may not look like in the end. We ask for public written comments and hold public comment hearings with the hope and expectation that the input of those with more knowledge of those issues than I or others on the Commission have will help guide me and the Commission to draft recommended rules that address stakeholders' concerns and incorporate their suggestions. Ideally, the final product should be rules that, if not meeting every concern or demand, at least balance the various and competing interests that are brought before us. So, in summary, the proposed rules that were put out by the Commission should not be viewed as a final version, but rather as just a first step in a work in progress that will be shaped and further amended as we work together through these issues. A few preliminary matters before I turn to the procedures we'll be following today. I just want everyone to be aware that, consistent with Commission practice, we are webcasting this hearing, and we have a court reporter that's taking down everything that's being said. So I'm going to ask everyone to please speak one at a time, speak slowly, and speak clearly to ensure a complete record is made. Please also note that the chat function normally found in Zoom has been disabled for this hearing. So do not try to make comments in that chat function. All right, now let me go over how the public comment hearing will proceed. First, you may provide written or oral comments to the Commission. Written and oral comments will be given the same weight. The Commission does not give any greater weight to oral or written comments. And in fact, the Commission actually prefers written comments, primarily because people tend to be clearer and are more persuasive in writing than when they present comments orally. They can also be more easily reviewed at a later time. If you would prefer to submit written comments, there are 4 primary ways for you to submit them. 1, through the Commission's electronic filing system that can be found on the Commission's website. 2, through the File a Comment or Complaint link on the Commission's website, by email, or snail mail. The PUC's website address is puc.colorado.gov. The Commission's email address and mailing address can be found on the Commission's website. To provide a written comment in any of these 4 ways, please include the proceeding number of this proceeding, which is 24R-0306E. And as I said, the Commission also accepts oral comments. In addition to providing oral comments here today, you can also leave the Commission a voicemail message with your oral comments at any time by calling 303-869-3490. Again, that number is 303-869-3490. Please note, though, that if you leave a voicemail message with your comments, be sure to include the proceeding number of this proceeding, which again is 24R-0306E. Your voicemail message will then be transcribed and your comments will be placed in the record of this proceeding, and I will review them. Okay. I'll now go over the steps for providing public comment today during this hearing. First of all, if you haven't already done so, please change your Zoom name to your first and last name. And in addition, please indicate, if possible, the organization on whose behalf you are appearing here today. This is very important so that we have a clear record, and also so that I know on whom I should call to speak. It helps me to know who you are and who you're with. All right, in order to let me know that you'd like to make a comment, I'm going to ask you to use the raise hand Zoom feature to signal that you wish to speak. If you don't know how to do it, you click the reactions button and click raise your hand. Leave your hand raised virtually until you have been called on. If you no longer wish to speak, please lower your hand. And if you don't know how to use the raise hand feature, you may instead turn on your video to signal that you wish to speak. That will let me know as well. All right, to reduce background noise or other distractions, I'm going to ask everyone to please mute your microphones and keep your cameras turned off until your name is called, which I see everyone is complying with already, so thank you. Once your name has been called, unmute, and I will call on you, and then you may speak. And once you have finished comments, please remute your microphone after you are done speaking. I'll continue my comment, but I see there's a hand up right now. Would somebody like to speak? Eleni Sklavendaitis. I'm not sure I'm pronouncing that correct. Would you like to say something?
Oh, it was just, I was raising my hand for comments.
Okay, we will get to that portion in a minute. Let me finish, please, giving the directions on how to do it, and then I will ask for comments in an orderly fashion, okay? Okay. To be clear, I need everyone to also speak slowly and enunciate as well as possible. Only one person may speak at a time. Do not speak over one another. We have to ensure that the court reporter can hear and understand your comments so that we get an accurate record of the proceeding. Also, if someone has covered all of the points you intended to include in your comments, please feel free during your comments to merely state that you agree with the points made by that other person. There's no need to repeat a comment someone has already made. We will hear it all and we'll consider it, I promise. Likewise, if you've submitted written comments and have nothing further to add in addition to the written comments you've already submitted, you don't need to also provide verbal comments today, just reiterating what's already in the record. The commission, as I said, has received many written comments in this proceeding, and we are working our way through those as quickly and as thoroughly as possible. To anyone who is participating in this hearing by phone, you have different instructions on how to participate, so please listen carefully. I'm going to tell you how to do that. To those by phone, you will need to dial *9. That will allow you to use the raise hand feature and let us know that you are interested in making a comment. Then please listen carefully, very carefully, for your area code and the last 3 digits of your phone number. When your number is called, you will need to dial *6 to unmute yourself. So again, *9 to raise hand if you're by phone, and *6 to unmute and speak once you're called on. When I call your name or phone number, please unmute, turn on your video if you have that capability, and begin your comments by stating your first and last name. When you are speaking, please remember that we have a court reporter making a transcript of everything that's being said. Speak slowly and clearly, and please do not interrupt or speak over others who are already giving comments. The court reporter may interrupt you and ask you to repeat yourself or slow down if she's having trouble hearing you. And then to those of you who are here today who do not wish to speak or do not intend to make comments and are only here to observe, we are live streaming this hearing on our website. The link is in the bottom right corner, puc.colorado.gov/webcasts. We are in hearing room A, I believe. If that's incorrect, I'm going to ask somebody to correct me, but I think we're in hearing room A. And if you are not making comments, I would ask that you please use that webcast to observe the hearing and leave the Zoom meeting. It will be less confusing for those of us who are here. You are always free to join back at any time if you wish to make comments. And like I said, we're webcasting live through the Commission's YouTube channel, so you can watch it through that. Okay. So because of the complexity and of the proposed changes to the Commission's electric rules and the vast scope of the comments the Commission has received thus far, I intend to proceed in as orderly a fashion as possible to keep this hearing moving along in a manner that those participating in the hearing and those watching in the live stream can follow. Also, it helps me later when I'm trying to make decisions on this to have comments grouped together so that I can find them and address them in my decision. So I'm going to go through the proposed rule additions and changes rule by rule, and we'll ask for comments about specific sections in the order in which the rules would appear, or close to it. Because there's much interplay between the proposed rule additions, I intend to take them just slightly out of order. I believe that approaching the rule changes in this way will allow the discussion to move along in a logical and organized fashion. So please listen carefully so that you know what rule we're talking about. I also want to say, though, that if there's any participant in attendance at today's public comment hearing that has time limitations that necessitate providing a comment about a proposed change before I get to the rule you want to talk about, please let me know by raising your hand so that I can ensure that all participants are given an opportunity to provide verbal comments at this hearing. Okay, before we start talking about the rules, does anyone have any questions about the procedure and how we're going to proceed today? Go ahead and raise your hand if you do. Okay, I don't see anybody. If any, okay, is that Carl Kumley with the Ute Nation? Go ahead. Do you have a question?
It is. Thank you, Your Honor. Good morning.
Good morning. And if you have video, would you mind turning it on?
Yes, thank you.
Thank you. I always prefer seeing who I'm talking to if I can. Hello.
Thank you very much, Your Honor. And Harriet, are you able to hear me? I'm
Sorry,
hoping.
yes, I am. Hard to get to unmute.
Thank you very much. Your Honor, we had a threshold question on behalf of the Ute Mountain Ute Tribe, and that is to ask whether Your Honor would like to consider procedural comments before dealing with the substantive aspect of the rules, if that would be helpful, or if you have a process in mind that you would rather follow.
I guess what procedural comments did you wish to make? Are these in addition to what was in the written comments that were already submitted?
In particular, whether it would make sense to bifurcate or split off a particular portion of this hearing regarding things like significant sites and their definitions, and having a process for addressing those as we go forward.
Well, I mean, it's a little difficult for me to consider that off the cuff at the moment because it kind of depends on what happens today.
Okay.
So if you could give me the context, I guess, about the procedural matter you want to describe to me, and then I'll keep it in mind. But probably for now, I think we should march forward and see how things go. And if I find it so unwieldy that we're not making progress, then I would certainly consider something like that. But please go ahead and give me your reasons for thinking that that might be a good thing to consider.
I'll stand down for right now, Your Honor, and if it seems appropriate later, I'll go ahead and renew our request.
Thank you. And am I pronouncing right? Is it Mr. Kumley?
Kumley is exactly right. Thank you, Your Honor.
Wonderful. And yes, Mr. Kumley, I did notice that the significant sites definition did garner a significant, no pun intended, amount of comments. And I do recognize that that's a very broad topic, but I'm hopeful that if we march through and maybe address that first, we'll see, because that definition will then play into many of the other rules. So maybe rather than bifurcating, we can short circuit some of the conversation by addressing that head on first.
Thank you very much, Your Honor.
Thank you, Mr. Comley. I appreciate the consideration of that. It's a thoughtful comment. Appreciate it. All right. Before we get into significant sites, I'm going to try and go through the rules in a somewhat orderly fashion. So let's now turn to the public comment portion of this hearing. And I'm going to try and start with the definition rule first. The first definition that was changed or actually added to the proposed rules was a definition for cultural and historic resources. The NOPR proposed that that be defined as, quote, cultural resources, human remains, and associated funerary objects, view sheds, and sacred objects, end quote. We've already received and I've considered some written comments that have suggested adding the word tribal to the defined term and changing human remains to ancestral remains. Are there any other comments about the proposed definition of cultural and historic resources that anyone would like to make at this point? Any hands up about that? This is Rule 3001-3001, subsection little I. Okay, I don't see any hands up about that one. Okay, so I think people are resting on, I'm going to assume that that means that people are resting on the written comments that we've already received and I mentioned. So we have received them, we are considering them. Okay. Before I get into the definition of significant site, which would be the next chronological one in the rules, which, as I indicated, is a fairly broad topic, I would like to get comments about the definition of tribal nations as federally recognized tribes. I do note that one comment suggested referring to tribal governments instead of tribal nations. I guess if somebody could provide me with a little bit more context on that proposed change, I'd appreciate it. And I would like to know if there's any other comments about the proposed definition of tribal nations, which is Rule 3001, so 3001, subsection SS, SAM. Anyone have any comments about that? Okay, I don't see any hands up about it, so I guess the written comments will prevail on that then. So we'll just go off of those. All right, turning to Rule 3001 MM, Michael, which is the definition of significant site. This is the definition section, and I'll turn after we talk about the definition to the Rule 3620, which is the steps for identifying and treating significant sites in commission proceedings. So with respect to the definition of significant site as proposed in the attached rules to the NOPR, the proposal currently states that a significant site is defined as, quote, the Sand Creek Massacre National Historic Site located in Kiowa County, Colorado, that commemorates the November 29th, 1864 attack on a village of Southern Cheyenne and Arapaho people along Sand Creek by the Colorado Volunteer U.S. Cavalry. 2 is a site that is registered within the Cultural Resources Database maintained by the Office of Archaeology and Historic Preservation within History Colorado, and is listed or eligible for listing on a local, state, or national register of historic places. Or 3, a site designated by the commission as a significant site within a particular proceeding. We have received, as I indicated, several comments about this, one of which even proposed we expand the definition to include and add the Meeker Massacre site of 1879 as a listed significant site. But would anyone wish to make some public comment at this point about the definition, a proposed definition of significant site in Rule 3001 MM? Go ahead and raise your hands. Okay. I'm not seeing any hands up about the definition of significant site. Okay, I'm going to assume that that means that those who have submitted written comments about the definition are have nothing to add to those written comments. Okay, last chance to talk about the definition of significant site, which I do understand, has some wiggle room, I guess, for how we're going to define it. All right, moving along then to Rule 3620. So I'm skipping ahead in the numerical order of the proposed rules, and I want to discuss the addition of a whole rule, Rule 3620, to the electric rules, which would address significant sites, because discussing the procedures for significant sites goes hand in hand with discussing what the definition would be. So Rule 3620 seeks to establish the procedures utilities must follow for identifying and mitigating impacts to significant sites. It has numerous steps, and I'd like to take each step in turn. All right, the first step is the identification of impacts to significant sites. It covers both actual and potential impacts, requires inclusion in applications, and requires notice to affected tribal nations or governments, as well as the Office of Archaeology and Historic Preservation. So I believe this is a 3620, I think it's A. I don't have the rule. I don't have enough screens to have the rule up in front of me as well, but does anyone have a comment about the first step of Rule 3620, which is the identification of impacts to significant sites? Please raise your hands if you do. Okay. I'm not seeing any other additional hands up, so no one has any comments to add about the identification of significant sites. Okay. The next step under Rule 3620 is pertains to information regarding significant sites. It's setting out the information that a utility must include in its application about significant sites. So does anyone have a comment about this proposed requirement, which would be to require utilities to include information in their applications about significant sites or potentially significant sites? If you do, please raise your hand. I am not seeing any raised hands. Okay, again, I guess I'm going to presume that that means that those who have submitted written comments don't have anything to add to those written comments and that they're going to rest on what they've already submitted to the commission. Okay, the next provision of 3620 grants tribal nations or tribal governments the right to intervene in any relevant application that affects a significant site. It requires tribes to intervene within 30 days of notice of the application or within 30 days of identification of a potential impact to a significant site. Does anyone have a comment about this proposed requirement? Which would, like I said, this is the intervention right granted to tribal nations. I don't see any hands up, so nobody wants to comment on that. Again, you want to rest on the written comments that have already been submitted to the commission about this provision. Okay. The next section of Rule 3620 states that a tribe can come to the commission and ask that a site be treated as significant and explain to the commission why it's necessary for the site to be so designated. Does anyone have any verbal comments they'd like to make at this time about that step in Rule 3620, which is, like I said, the proposal to allow tribes to ask the commission to treat a site as significant and explain why it should be so treated? No, no one? No comments about that either? Oh, Mr. Kumley, go ahead, please. Thank you.
Thank you, Your Honor. I am trying not to recapitulate our written comments on behalf of Ute Mountain, but we do believe that it is important for the commission to recognize that it may not be possible in all circumstances for a tribe to specify why a site should be treated as significant. There is knowledge which is kept sometimes by individual clans or individual societies within a tribe where that information is particular to that moiety, that clan, or that society, and is not shared even with other tribal members. So there may be cultural limitations on what can be shared with outsiders, particularly in a very public forum like the commission, as to why a particular site is invested with significance from the tribal perspective.
Thank you, Mr. Kumley. I did read that, and I appreciate you being careful not to reiterate what's already been provided in written comments. But on the other hand, I do appreciate the opportunity to at least try and have a discussion about these things today. Hearing that, I guess I understand that there are certainly topics that can't be disclosed because of their extremely sensitive nature. But I would like to know, though, is there some information that could be provided? Like, we can't, you know, would a tribe be willing to say something to the effect, I suppose, of, you know, we consider this to be a culturally significant site for reasons that are sacred to us, and we can't divulge at this in such a public forum. But I guess my concern would be, you don't want to be in a situation where someone is just proclaiming it. We you know, what assurance would a tribe be able to give them that the site is indeed significant?
Thank you, Your Honor. I think one way that it can be addressed is through a tribal historic preservation officer as a conduit to the commission. Obviously, there may be certain things that can be said about a particular site. It may not be possible to explain every element of significance or interrelations with other sites or the particular reason that a site has significance during a certain season of the year or something like that.
Okay. Do you have any proposed language that you would recommend we consider?
I do not right now, Your Honor. I will try to work on something to address that that question and see if we can go ahead and get something for your use, Your Honor.
That would be wonderful. That would be very helpful. It helps us to have at least a starting point that we can work off of so that
Great.
we're not creating something from whole cloth.
Thank you very much. You know, a tribal resolution or a letter from the Tribal Historic Preservation Officer may serve as conduits to provide the appropriate level of information from the tribal perspective to the commission.
Thank you, Mr. Cooley. That very well may be. Appreciate that.
Thank you.
Does anyone have any comments in response to Mr. Cooley's comment? No? Nobody has a hand up? I don't see any. Okay. Let me then move on to the last step set out in Rule 36, proposed Rule 3620, which is that a utility must include, quote, appropriate protections for information about the site. As I understand it, this provision requires the utility to indicate how it will work to protect a site. Are there any comments about that step in Rule 3620, a step requiring the utility to lay out how it will protect a site? Nobody has a comment about that either? Everybody's okay. Well, as I've said repeatedly, we did get a lot of excellent written comments. So if you think you've thoroughly hashed it out in the written comments, that's great. We have them and we are taking them into consideration. But if there's anything you want to add, now's your chance. No? Okay, great. All right, we've sort of discussed the scope of implementation of the rules for significant sites. So now let's turn to some of the other rules and discuss how the definition of significant site and the application requirements pertaining to significant sites will affect the remaining rules. Those terms have now been proposed to be incorporated into certain other rules that are already existing electric rules. So let's first turn to Rule 3102, which is the Certificates of Public Convenience and Necessity, which, as I said, are referred to as CPCNs for facilities. The NOPR proposes adding a provision requiring that a utility's CPCN application to construct and operate a facility or to extend a facility include information addressing, quote, impacts to significant sites as detailed in Rule 3620 and actual or projected costs associated with avoidance or mitigation of impacts. The utility shall further submit any cultural resource surveys or analyses required by federal, state, or local agencies, end quote. Okay, does anybody have a comment specific to Rule 3102 about including this information in essentially CPCN applications? No, everybody's okay with that. And like I said, we've received many written comments. So if you don't have anything to add, that's great. We've got the written comments and we are in the process of considering them. I don't see any hands up on 3102. So let's move on to 3605. This is the rule governing cooperative electric generation and transmission associations. There are a few changes, I think 3 changes proposed to this rule, to Rule 3605. The first is to subsection G, Roman numeral 2, capital letter G, small Roman numeral 4, IV. The NOPR proposes that at the phase 1 stage of a project, that's at the initial planning stage, cooperatives be required to ask any potential bidders responding to the cooperative's request for proposal to provide information regarding impacts to significant sites and the historic and cultural resources thereof, as again detailed in Rule 3620. So is there any comment about requiring bidders responding to a cooperative's phase 1 request for proposal to providing that information in their bid? No, I don't see any hands up about that. Okay. The proposed changes to 3605 are all related. The next one is at G3C, capital letter C, small v, small Roman numeral 5. There, the NOPR proposes adding the provision to the phase 2 stage, mandating that the commission itself, quote, address the sufficiency of the utilities consideration of significant sites and the cultural and historic resources thereof within the proposed RFP, model contracts, evaluation criteria, and other relevant activities. So this is a proposal that would require, when the commission is reviewing and making a decision at the phase 2 stage on a cooperative's application, that it determine whether the utility has, so I guess, sufficiently considered significant sites in the historic cultural sites and the impact on them. Any comments about that? No, I don't see any hands up, so, okay. And then last, the NOPR proposes adding an element to a phase 2 decision about cooperatives, requiring the commission again to, quote, consider the sufficiency of the regulated utilities treatment of significant sites and the cultural and historic resources thereof, and if relevant, whether mitigations or alternative actions are viable and cost effective. In so doing, the commission shall address how it has considered information presented by tribal nations in rendering its decision. All right, any comments about requiring the commission to include this in a phase 2 decision? Okay, Mr. Hefner from Tri-State, please go ahead and speak.
Good morning, Your Honor. Dietrich Hefner, outside counsel for Tri-State. You know, I think we're going to mainly stand on our written comments, but given that 3605 really only applies to Tri-State, I wanted to let you know that we are here. I'm here as well as Steve Gray, who is Tri-State's Senior Manager for Land Rights and Permitting, Chris Reichard, who is Tri-State's Senior Environmental Policy Analyst, and Sarah Ruin, who is Tri-State's Senior Regulatory Manager, are all on the call. And certainly if you have any particular questions for me or for them, we are here and ready to address them. But as I said, I think our written comments pretty comprehensively cover the proposed rules, so I won't repeat those comments here.
Thank you, Mr. Hefner. And like, as I said, we've received them, we've read them, and we're in the process of analyzing it, I guess is fair. There were extensive comments from so many entities, it was almost difficult to get through all of them before today. So, but thank you.
I feel your pain. Thank you.
But I'm very pleased that we had such thoughtful and thorough comments. I mean, that really makes our job in the end easier. So thank you, Mr. Hefner. Dr. Norton, you've got your hand up. Would you please identify yourself?
Yes, Your Honor. I'm Holly Norton. I'm the Colorado State Archaeologist with History Colorado.
Welcome.
Thank you. And thank you for this hearing today. I think my comment for 3605 is I would urge the commission not to delegate too many responsibilities to the applicants and to the energy offices or to these energy companies that might rightfully stay with them. You know, I think in this case for this last set of proposed rule changes, it might be more appropriate for the commission to make these considerations based on information provided through the initial scoping from the companies, instead of asking the companies to both do the scoping on cultural resources and then to also make recommendations about their impacts or about their level of effects on these resources.
Okay, thank you so much for that. I guess the question that would then pop into my head, has popped into my head, is for the commission to consider it, though, it has to be brought to the commission's attention. So should there be some vehicle other than the application by which the commission would be made aware of the potential for significant site?
No, ma'am, I don't believe so. So the way that there are processes in place that are very similar to what the commission is proposing. And the way this often works with other federal or state processes is an applicant does gather, this initial information, and they are involved in different levels of discussion. But as kind of the lead agency, the commission kind of retains some authority and some decision-making power over what they perceive to be the impacts based on the information that the applicant has helped to collect. But some of these rules seem to delegate a lot of responsibilities to the applicants and to the developers. And I would just urge the commission to retain some of those decision-making powers for themselves as the state agency.
Okay. And is this proposal you're putting on the table one that you would apply more broadly, distributively to the rules in general, not just 3605?
Yes, ma'am, I would.
Okay.
Particularly, one that I have flagged, I believe, is discussions with the applicants and tribal nations or other stakeholders who are interested in the cultural resources. While I do believe it is incredibly important for applicants and developers and energy companies to have those conversations, I would urge the commission not to relinquish their government to government status when having conversations about impacts of cultural resources with tribal nations.
Thank you so much, Dr. Norton. That makes a lot of sense. Does anyone have any response they would like to make to Dr. Norton's comments? Okay, I don't see any other hands up. All right. Thank you so much, Dr. Norton, for making that comment and clarifying that the archaeology department's position on that. That's very helpful. All right, so let's move then on to the next rule, Rule 3613. This is the rule that addresses bid evaluation and selection. The NOPR proposes adding 2 sentences at the end of subsection H, as in Henry, which specifies that the issues the commission must consider when rendering a decision. The additional proposed sentences read, the commission shall consider the sufficiency of the regulated utilities treatment of significant sites and the cultural and historic resources thereof, and if relevant, whether mitigations or alternative actions are viable and cost effective. In so doing, the commission shall address how it has considered information presented by tribal nations in rendering its decision. All right, any comments about adding those 2 sentences at the end of Rule 3613, which addresses bid evaluation and selection? Does anyone want to talk about 3613? No, I don't see any hands up. Okay, just pause, bear with me for one moment. All right, sorry about that. I needed to check something. All right, let's move on. We just talked about, well, we didn't talk about, I gave the opportunity to speak about 3613. So there being no hands up to talk about 3613, let's move to 3616, the request for proposal section. This proposal is akin to the additions to Rule 3605, requiring cooperatives to ask their RFP bidders to address impacts on significant sites. Proposed Rule 3616D would require utilities to ask their RFP bidders for, quote, information regarding impacts to significant sites and the historic and cultural resources thereof, as detailed in Rule 3620, end quote. So does anyone have a comment about 3616, which applies kind of the same requirement on the utilities as it does on the cooperatives? Okay, I see the hand up for Ellen Kutzer. Am I saying that right? If you could state your name and, oh, good morning. Thank you.
Good morning, Your Honor. It's Kutzer, but it's nice to be here. Ellen Howard Kutzer for the Colorado Solar and Storage Association, as well as the Solar Energy Industries Association. I'm going to endeavor to not repeat what we've already put on the record in our written comments, but I did want to chime in here and just state how important we think that the treatment of this section of the rules is from the developer community perspective. We do have concerns that leaving the utility as the arbiter of deciding whether or not a developer has adequately addressed impacts to significant sites gives us great concern. And similar to Dr. Norton's sentiments, I think we also feel that we'd prefer the commission to have a role here in helping to make those decisions and ensuring that decision-making about the protection of significant sites and the adequacy of that isn't made exclusively by a utility behind closed doors. I don't mean that to be insulting to our utility friends, but this is just not something that they typically do. It would be a new process for them, and one that, if not well policed, could result in unintended consequences, as we pointed out in our comment, excuse me. So just wanted to stress that again, trying not to be repetitive, but this is a key consideration for our members. Thank you.
Thank you, Ms. Kutzer. Kutzer, did I say it right?
Kutzer, yeah.
Kutzer. Sorry. Thank you so much. That's very helpful. And yes, it goes hand in hand with what Dr. Norton was saying. So reiterates and underlines that that may be something we do need to take a more closer look at.
Great, thank you.
Let me ask you, Ms. Kutzer, do you have proposed language that you would recommend for a proposed rule, and how would that play out?
So we did not include proposed red lines for a couple of reasons, and those are because there were so many fundamental issues related to definition issues and I'll say process issues. We weren't sure that we could correct what needed to be corrected, in our opinion, through red lines. And I think that relates to, the scope of what's looking at being protected, the definition of cultural resources, the definition of significant sites, as well as I think these fundamental questions about timing and the time in which developers would be asked to provide information to the commission. So I will take this opportunity to say that that is also a very critical issue for us. The way that we read the proposed rules, developers would be asked to submit significant information earlier in the process than what they are doing right now. They typically do comprehensive significant site surveys later in the process, and that information is submitted as part of the 1041 siting and permitting process at the counties. As we read the rules, they would require that information to be submitted to the utilities much sooner in the process. So we believe it would be worthwhile to have a comprehensive conversation about what that change in process looks like, as well as the mechanics of how it affects significant site protection. But I'll stress that we do think this is a pretty significant change from the way things are being done today, and one that I think needs to be addressed before we be comfortable with underlying red line language. So I hope that's understandable to the commission, but just wanted to stress that.
And like I said, we do have your written comments and are reviewing them, taking it under consideration. So it will all be part of the record. I appreciate you making additional comments here today. Anything else?
Thank you. That's all. Thank you for listening.
Of course. That's why I'm here today. Does anyone have any responsive comments they want to make to Ms. Kutzer's comments? Okay, I don't see any hands up. Okay. So moving along, that takes us to Rule 3617, Commission Review and Approval of Resource Plans. The proposed changes to this rule propose that the Commission decisions addressing resource plans be required to include a statement addressing, quote, the sufficiency of the utilities, consideration of significant sites, and the cultural and historic resources thereof within the proposed RFP, model contracts, evaluation criteria, and other relevant activities. So this proposed language is very similar to the proposed additions to both Rules 3605 and 3613. Are there any new comments or additional comments you want to make about requiring the Commission to address whether and how a utility has considered significant impacts, whether a utility has considered significant sites in its proposals as required by proposed changes to Rule 3617? Anyone else? Okay, I don't see any hands up. Okay. As I said, that's similar to other changes in other rules, and so we have talked about them to some extent. Okay, the next rule is Rule 3618. The NOPR proposes requiring utilities to include a section in their annual progress reports describing, quote, any ongoing discussion and or consultation with tribal nations regarding impacts to significant sites that were identified in the most recent resource planning proceeding. Are there any comments about adding this requirement to utilities' annual reports, requiring them to let the Commission know about any ongoing discussions they're having with tribal nations about significant sites? No, I don't see any. Okay. I did actually want to throw out one kind of related comment to that, or a related question to that. And that is, that rule talks about consultations. And I guess one question that was raised was consultations that are happening between government to governments. And it's been asked of the Commission that we consider consulting. And I wanted to know if anyone has any views or comments they would like to provide, helping the Commission to understand what kind of consultations are being considered or are being proposed that government to governments have between, I guess, the Commission and tribal nations. Does anyone have any insight that they could provide to us about what that consultation term would mean? Mr. Kumley, please go ahead.
Thank you, Your Honor. We mentioned in our comments, and so I won't belabor it here, but we believe that there is an important role for the Office of Archaeology and Historic Preservation to play in a government-to-government relationship. There also is a role for tribes to play as part of a government-to-government relationship. And we believe very strongly that consultation is never a one-off. That is to say that there is a need for continuing engagement, and then consultation happens as a result of a positive relationship which is grounded in ongoing engagement, and then consultation is something that happens with regard to particular landscapes and particular sites. So we do think that it is important to systematize the relationship, the government to government relationship, on an ongoing basis so that there is a regular conduit for communication between tribes, the commission, and OAHP.
Thank you, Mr. Kumley. If I understand correctly, then you're not suggesting that consultation necessarily occur during the litigation. It almost sounds to me like you're envisioning a process that's at a pre-litigation stage. Is that correct?
I would say that engagement has to take place at a pre-litigation stage. Consultation is likely to be project specific, but engagement needs to happen regularly, and it needs to happen in the context of adequate notice from bidders, from utilities, of the location where utility activity is likely to take place, so that we have a context for evaluating potential effects to significant landscape, significant sites.
Okay. Once a matter is in litigation, though, what would that consultation? I mean, how would you envision that consultation form takes place then? Because once it's in litigation, different due process requirements come into play. So, would you envision that as a public conversation then? Would it entail discovery? We're just a little. I want to make sure that I understand how you envision it once the litigation piece comes into play.
Well, once there's litigation, Your Honor, there will be a need for development of a record through discovery.
Mm-hmm.
There will be a need for perhaps the commission to direct the parties to meet and confer and respond to a concern together, or to set forth their divergent opinions. So I don't have a particular recommendation setting forth right now, other than to say that where there is an impasse, mediation becomes a very important tool to be used in trying to resolve some of those possibilities or some of those conflicts.
Okay. Thank you so much, Mr. Kumley. That was very helpful. We were talking amongst ourselves, trying to understand what that might mean and look like. So that's extremely helpful to get your perspective on that.
Thank you.
Dr. Norton, Dr. Norton has her hand up. Go ahead, Dr. Norton.
Yes, Your Honor. Thank you. I think that this idea of consultation can also help clarify some of the earlier comments and conversation from this hearing. So, for instance, Mr. Kumley brought up, and you asked him about how the commission or applicants to the commission might go about preserving the sensitivity of maybe a cultural site, but still providing enough information that the commission is able to identify a significant site from tribal nation concerns. And I would recommend, and again, I think this hopefully helps clarify some of my earlier comments about the commission not delegating too many of their privileges and responsibilities away to applicants. If the commission is in consultation with subject matter experts, from whether it's from my office or elsewhere, as well as tribal representatives, they can help have those conversations about sacred sites, sensitive sites that might not be appropriate in a more public application or a public hearing. I'm going to stop there because I've slightly lost my train of thought, but I do believe that it would be very important for the commission itself to engage in consultation and to be that conduit for applicants for the utilities and not just delegate it away. Thank you. Sorry.
Thank you so much, Dr. Norton. I appreciate your comments and your help. All right. Any other comments about that topic or about Rule 3618, which we had started talking about? Okay. I don't see any other hands up, so let's move on to actually what is the last rule that has proposed changes to it, which is Rule 3627, which addresses transmission planning. There are two proposed changes to Rule 3627. The first is in subsection C as in cat for addressing the 10-year transmission reports. The NOPR proposes requiring utilities to add a discussion identifying, quote, communications with tribal nations regarding significant sites, end quote, in their 10-year transmission reports. So this is requiring a utility to identify in its 10-year transmission reports whether and to what extent they've had communications with tribal nations about significant sites. Does anybody have a comment about requiring utilities to include those in their 10-year transmission reports? Mr. Kumley, please go ahead.
Thank you, Your Honor. We do think that's appropriate, and I don't know that our comments specifically address the 10-year reports. We do think that that it is important. However, once again, with regard to this rule, as we've stated elsewhere, we believe that it is important not to just, and particularly in the transmission context, not just to address significant sites, but also significant landscapes. So to the extent that that has been omitted, we would want to make that point here as well.
When you say significant landscapes, how broad is that? How do you define that term? What does that mean?
Well, it will vary. We used in our reply comments the example of taken from the Hopi tribe of what are called the Hopi Buttes, which operate as a calendar for planting and agriculture when viewed from different locations at different Hopi villages. I can foresee a situation where a transmission project might affect different significant landscapes differently for each of those villages, and what the impact of transmission routing close to the Hopi Buttes might be. So I do think it is difficult to wrap arms around, other than to say that it is important for transmission planning in particular, for there to be an identification and ongoing analysis of what significant viewscapes look like, or significant view shifts look like.
Okay. Thank you so much, Mr. Kumley. I appreciate you clarifying that for me. Thank you so much. Does anybody have any comments responding to either Dr. Norton or Mr. Kumley? Or I believe it was just Mr. Kumley that had comments about the transmission planning. I'm sorry, I'm confusing myself. Anybody have any responses to Mr. Kumley's comments about Rule 3627? Okay, I don't see any hands up, so let's move to the last proposed change to the rule, which is 3627 subsection G as in grape. This change would grant government agencies the opportunity to meaningfully participate in the planning process, and specifies that government agencies includes tribal nations that are affected by impacts to significant sites. Does anyone have any comments about expanding the definition of government agencies in the transmission planning rule to include tribal nations? All right, I don't see any hands up about Rule 3627. Okay. Oh, Ms. Boston, you have your hand up. Go ahead. Oh, you are not Ms. Boston. I think you, can you change your name possibly?
Possibly.
If not, at least just state your name for the record. There should be a way, I think if you click on the box, there's 3 little dots that appear in the upper right corner of your box. Oh, you got it.
I got it. I clicked on the link through the commission's calendar to get here, and so I think that's why I showed up as Jennifer Boston. But I am not Jennifer Boston.
And for the record, Jennifer Boston is a commission employee and a wonderful, wonderful person who we rely on every day. So thank you, Jenny. Go ahead, Mr. Desky. Can you tell us state your name again for the record and indicate with whom you are here? Who are you representing?
Mark Detsky, representing the Colorado Independent Energy Association, or CIEA.
Okay, go ahead, Mr. Detsky. What comments do you have?
Well, I want to support for CIEA the outreach to tribal governments by utilities in the context of 3627 reports and the lines they're thinking about in some point down the future. But I don't know the extent to which Your Honor is being familiarized with Rule 3627 reports, but these planning reports are essentially informational filings that are done every 2 years that show just big gigantic ovals on the map of Colorado for where a future line may go, and they're conceptual, even to the point of electrically conceptual, although there is a section for near-term projects, but there's no real connection between the 3627 report, at least historically in the commission, and any line that's actually been proposed for approval in a CPCN context. There's never been, in my experience, a line that appeared in one of those reports that then later on was developed. So it's more like a snapshot of internal utility electrical planning that at that point in the report has really no bearing with anything on the ground. But it is early enough in the transmission planning process that utilities doing outreach to tribes, as they are already supposed to do to other governmental entities, that's an appropriate, I think, point in the process to do outreach. So support it in that context, but then, in terms of like what Mr. Cooley was talking about, in actual siting is, they're not even to the point of proposing an electrical solution to the commission at the time those reports are filed, generally speaking.
Got it. Thanks so much for that background, Mr. Detsky. That's very, very helpful. I appreciate it. Educates me on how it all works. All right. Anybody have a responsive comment to Mr. Detsky's comments? No? Okay. All right. We've actually already made it all the way through the proposed rules, rule changes contained in the NOPR. Now, I'd just like to open up to ask for any general comments. First, is there anyone who has a comment proposing additional rules that they think should be incorporated into the electric rules that were not contained in the NOPR? If you have such a proposal, please let us know. Let me know now and indicate why you think it should be added, and if possible, the language you think that we should include. And I'd also offer, if you don't want to make a public comment about making such a statement here and now, please also consider offering additional rule language in a written comment so that we can ensure we fully understand your proposal and have transcribed it accurately. But right now, does anyone have a verbal comment they'd like to offer indicating their belief that we should add other rules in addition to what's already been contained in the NOPR? No, I don't see any hands up. Okay, but again, if anybody thinks of something and you have a proposal, please go ahead. Please go ahead and offer us a written comment including that. Okay. Finally, then, having marched all the way through the rules and open up the floor for additional rule proposals, I would just like to ask if anyone has any final comments they'd like to make addressing issues that we have not already discussed. Does anyone have anything else they would like to discuss or add or say? Now is your chance. Ms. Kutzer, you've got your hand up. Please go ahead. Oh, wait. Oh, I can barely see you. Okay.
Sorry, thank you, Your Honor. Again, I'm not going to try to be repetitive of what we've already filed, but I'd just like to state for the record that procedurally we see a lot of benefit in really taking our time before the commission moves forward with adopting final rules. We think there could be some tremendous benefit in talking through really what the status quo process is for developers, for utilities to do these surveys and identify significant sites now, and talk about improvements needed and how that relates to the PUC process moving forward. I have a ton of respect for the amount of work that the commission's put into these rules. I think this is an incredibly important topic as we endeavor on a historic energy transition that's going to impact a lot of land. And there's, no getting around that. But, I do think that as written, the proposed rules could represent a pretty significant change from the status quo. And before we go down that pathway, we'd really hope that the commission could gather more information and understand sort of the tremendous difference that this might represent. So thank you for considering that procedural pathway and for your time today considering all of the comments.
Thank you, Ms. Kutzer. And let me just say responsively quickly that, from my perspective, we're nowhere near done. I anticipate that this is going to be a multi-hearing proceeding where we're constantly fine-tuning and changing things as we go along. So this is a discussion. This was just a starting point. So I don't want anyone to have the impression that we are anywhere near the final product. We're just seeing where we are and trying to move forward with the information gathering. But I do envision that this is going to take some time. We'll have the time, and we're under no gun to hurry up. We're fine. We have plenty of time.
Great, thank you.
So thank you, Ms. Kutzer. I appreciate those comments and that perspective. Mr. Dietrich, Mr. Hefner, you had your hand up. Go ahead.
Yeah, thank you, Your Honor. I'm going to echo a little bit Ms. Kutzer's comments in that Tri-State really appreciates this effort and recognizes the importance of avoiding culturally sensitive sites, including tribal sites, and certainly share the Commission's commitment to getting this done right. I just want to underline a couple things from our written comments. As you say, and I'm encouraged to hear you say we're sort of at the beginning of the process here, not the end. And I think we have some real concerns about the scope of the proposed rules and the specificity, as well as the timing issues that Ms. Kutzer was just discussing about advancing the siting of projects, whether they be generation or transmission projects, to be much, much earlier in the process than it is currently. For example, the 3627 transmission planning reports are very, very early in the process, as Mr. Detsky was explaining. And they're just, there really isn't detailed siting information available at that stage. And so any rules that would contemplate detailed siting information being available at that stage would dramatically, can't state this strongly enough, dramatically change the way that transmission projects are planned. The other one I want to highlight in terms of timing is the CPCN. Even at the CPCN stage, there's say it's a transmission project, there's an identified endpoint and connection point for a linear transmission project, but the detailed route of that transmission project probably isn't known at the time a CPCN application is filed. And the route is typically selected after the commission grants a CPCN. And the reason for that is until there's a CPCN, we really don't have an affirmation from the commission that there is a need for the project. So the CPCN, in our view, determines the need for a particular project, and it's not necessarily prudent to go and do all of the land acquisition and siting and negotiations and environmental studies and species studies and so on at a stage where the commission or stakeholders may have other notions of what the project ought to look like or whether it's actually needed at all. So we do have some serious timing concerns. And then lastly, and I think we spoke to this extensively in the comments, this represents pretty new territory for the commission, getting into the siting, especially of transmission projects. And I think there are some legal concerns there about whether that's something the General Assembly has tasked the commission with, and certainly understand the tie to costs and the cost of avoiding impacts. But a lot of this does feel quite a lot like transmission line siting, which for us at least raises some legal issues. So we cover all of those things in the written comments. I won't speak more now. Really appreciate the dialogue today and the opportunity. I hope to meet further on this and discuss more.
Thank you so much, Mr. Hefner. I appreciate your comments. Mr. Kumley, you had your hand up next. Go ahead. Oh, you're still muted, Mr. Kumley.
Thank you very much, Your Honor. A couple of things. Number one, we respectfully disagree with Tri-State regarding the importance of evaluating these potential impacts and the ability to avoid at every stage, at early transmission planning stage, at the CPCN stage, and while it's not the commission's jurisdiction, at the 1041 stage as well. We also have a real concern with this proceeding dragging out ad infinitum. And particularly from a tribal perspective, we believe that the issues here are important, that the commission has very properly raised them in response to the concern from the Northern Cheyenne, Northern Arapaho, and the Cheyenne and Arapaho tribes of Oklahoma. And we congratulate them on their leadership in this regard. But this process should not be allowed to go on and wither and die. So if the commission, through you, Your Honor, is going to be taking additional time, we would ask very strongly that a procedural schedule be set and that we commit to keeping to that procedural schedule so that this rulemaking does actually result in rules which will guide utilities, which will guide bidders, which will guide the tribal nations that are going to be interacting going forward. So please, let's not let this proceeding languish, and let's move forward to a good conclusion. I also, in conclusion, need to apologize. When we took appearances, I did not introduce my co-counsel, Casey Cornelio of Cornelio Consulting, and also on the call today, Tribal Historic Preservation Officer Yassant Messier on behalf of Ute Mountain.
Thank you so much, Mr. Kumley. Let me just quickly state, procedurally, I won't be ending this today because I simply there's too much information and I need time to process it. The way the rulemakings work before the commission is we hold one more or a series of public comment hearings. I intend to set one at the end of this hearing, and then at the next one, we'll make a decision whether we need another one. But rest assured, it's not going to be languishing if we can help it. And it's just a question of making sure that we are at a point where I feel like I have enough information to make a decision. And at this point, we're not there. So it's not languishing. It's just making sure that we have all the information we need to issue a good decision. I mean, and to issue the most informed decision we can. That's my goal.
Thank you, Your Honor.
Thank you, Mr. Kumley. Dr. Norton, you've got your hand up. Would you like to go ahead?
Yes, Your Honor. Thank you. I just wanted to state for the record that History Colorado and the Office of Archaeology and Historic Preservation is very supportive of the concept of these changes. And we really look forward to more dialogue and having some more informed comments in the future. Because we have not always worked closely with the commission and on commission projects, some of the nuances that have been brought up today were not clear to us, but we would like to continue to work on that. I think the only other thing I would like to say is just to clarify and underline some of our written comments, that there are processes and practices that are already adhered to for development projects in general, kind of writ large in Colorado. And we always believe that conforming to those instead of recreating the wheel, or at least adhering to those as is appropriate, causes less confusion for the agencies, the developers, and others who are involved in this process. So if we can continue to be part of those conversations, we would be very appreciative. And thank you so much for listening to us today.
Well, thank you, Dr. Norton. We appreciate having you here and gaining your perspective. It's very helpful to us. And if you have any questions about how this procedure works and how the rulemaking works, please, ask your questions. If not here today, give us a call. We'll try and answer them, because we're not trying to hide anything. We want everyone to feel comfortable making the comments so that we can have them before us to be properly considered. Okay, I see a hand up. Alexa Roberts, go ahead, please. If you could state your name for the record and indicate with whom you are here.
Thank you, Your Honor. My name is Alexa Roberts. I'm on the board of directors of the Sand Creek Massacre Foundation, and I am here with our executive director, Eleni Sklavenides. We have provided written comments, Your Honor, but our board of directors has asked that we also include a verbal statement for the record. We are the nonprofit partner of the Sand Creek Massacre National Historic Site. We contribute to its educational mission. We commend the Public Utilities Commission for its consultations with the Cheyenne and Arapaho tribes leading to this rulemaking process. We strongly support the proposed definitions of cultural and historic resources to include viewsheds and significant sites, especially the Sand Creek Massacre National Historic Site. Congress entrusted the National Park Service to preserve the massacre site's cultural landscape as closely as possible to its 1864 appearance, and to educate the public about the natural and cultural resource values associated with it. Among these fundamental resources and values are the intangible spiritual qualities of the landscape, including extensive viewsheds to the north, east, and south. Being immersed in this landscape, visitors are able to understand the cultural and historical contexts in which the atrocity at Sand Creek occurred, and why the site is sacred, not only to the Cheyenne and Arapaho people, but to all Americans, just as other iconic sites, such as Gettysburg or Arlington National Cemetery, represent the nation's shared history and identity. Unlike these other sites, however, Sand Creek is the only national park unit named a massacre site. The 230 Cheyenne and Arapaho men, women, children, and elders killed there by the U.S. Army were never afforded the dignity of interment. Despite being promised to them by a U.S. treaty the land on which they were killed, it was stripped away after the massacre, forcing the Cheyenne and Arapaho people to relinquish their homelands in Colorado Territory. Contemplation of the difficult truths of this nation's story is especially powerful at Sand Creek because it is not surrounded by intrusions and distractions. It is arguably one of the most pristine settings of any National Historic Site in the country. Anticipating future intrusions on this setting, the Historic Site's 2015 management plan encouraged cooperation among multiple public and private entities for the protection of resources such as water, wildlife, and scenery, including, quote, designing structures and other energy infrastructure such as power lines and wind turbines to be compatible with ongoing efforts to preserve historic landscapes, views, and vistas. The Sand Creek Massacre Foundation supports the Public Utilities Commission's commitment to collaboration with the Cheyenne, Arapaho, and other tribal nations in the effort to find paths to energy infrastructure development that may be compatible with preservation of the state's most sacred landscapes. we thank you for the opportunity to provide these comments.
Thank you so much for your comments, Ms. Roberts. Most appreciated.
Thank you.
Thank you. Okay, I see a hand up from Mr. Parks Barroso. Am I saying that right?
Yes, exactly right. Thank you, Your Honor.
Okay, if you could go ahead and state your name and indicate with whom you are associated for the record. Thank you.
Certainly. My name is Parks Broso, and I represent Western Resource Advocates, or WRA. WRA greatly appreciates the Commission opening this rulemaking and Your Honor's consideration of the comments received thus far and today, as well as the opportunity to provide further comment. WRA would just like to observe that PUC staff recently released their capstone report on Senate Bill 272, Equity Implementation, and proceeding number 22M0171ALL. And that report concluded with the observation that the PUC has grown from keeping costs low and keeping power safe and reliable to increasingly incorporating environmental and social justice concerns in its practices, procedures, and decision-making. And we think that this is a useful framing and a useful sentiment to highlight here because this rulemaking is fundamentally a proceeding about incorporating equity and tribal perspectives into the Commission's practices, procedures, and decision-making. We appreciate procedurally what Your Honor has indicated in terms of the next steps for this rulemaking and a desire to continue moving forward with the promulgation of rules. Beyond setting additional comment and hearing deadlines, we would respectfully encourage the Commission to exercise its authority within this rulemaking to meaningfully engage with stakeholders and to solicit additional feedback. This could include encouraging informal collaboration among the tribes, stakeholders, and the Commission itself, convening one or more workshops, or calendaring time for presentation from entities like History Colorado. So wanted to present those options for Your Honor's consideration, and we appreciate the opportunity to comment.
Thank you so much, Mr. Barroso. I appreciate it. Does anyone else have a comment, either a comment they wish to make or a comment in response to those that we've heard from Mr. Barroso, Ms. Roberts, Dr. Norton, Mr. Kumley? Anybody have any additional comments they'd like to make? Okay, I don't see any hands up. Oh, Catherine Zing, go ahead, please. Can you state your name, please, for the record and indicate who you are here with?
Yes, Your Honor. My name is Catherine Zing. I'm currently the Tribal Policy Director for Good Alternatives. And just for the record,
Can you speak up a little? I'm having a little trouble hearing you. Maybe get a little closer to your microphone.
Yeah, of course.
Thank you.
My name is Catherine Zing. Is that better?
Yes, a little bit. Yes,
okay,
thank you.
Awesome. Yeah, half of my face is on the screen. Okay, my name is Catherine Zing. I serve as the Tribal Policy Director for Grid Alternatives. We have been submitting comments and do not want to necessarily be repetitive of what we have already submitted in this proceeding, but I would like to echo that we have a strong support for what Ute Mountain Ute has already stated, and that some high level ideas that are coming to mind as I'm hearing all the parties and individuals speak this afternoon is that there's a strong need to verify that tribal governments have been engaged and consulted during every phase of project planning, that there is also a need for the Commission to identify reasonable costs associated with these long-term resource plannings and filings, and that there's acknowledgement that the evolution to these processes, while they are new for the Colorado Public Utility Commission, are prudent, they are practical, and they are cautious in the timeline of future resource planning, in that this rulemaking must be fully coordinated with state agencies, a strong emphasis on coordination and cooperation, and that we also support Ute Mountain Ute's request that this rulemaking be met with swift timelines, as early publicized as possible. And with that, thank you, Pinagigi, from Grid Alternatives.
Thank you so much for your comments, Ms. Singh. All those will be taken into consideration. Does anyone have any comments in response to Ms. Singh's comments? Okay. I'm not seeing any hands up. Are there any final comments that anybody wishes to make about the proposed rules or the discussion in general? Now's your chance. All right. One last call for any final comments. Seeing that there are no other comments, I'm going to move towards closing this public comment hearing. So this is the last chance. If anyone has a public comment that they wish to make on the record, please do so now. Okay, I don't see any other hands up, so I think we can go ahead and move towards the next steps. If there are no additional comments and no additional participants who wish to speak or make comments at this time, we have come to the end of the comment portion of this public comment hearing. I want to thank all of you for your comments regarding the proposed modifications to the electric rules, for your participation, and for your thoughtfulness and presentations. All that will be taken into consideration and is greatly appreciated by the Commission. As I've indicated and hinted at throughout this proceeding, given the extensiveness and the complexity of the proposed changes to the electric rules, as well as the many, many excellent and informative written comments that the Commission has received, I am continuing this rulemaking hearing. There's a lot of information for me and the Commission to consider yet, and to do so thoroughly and thoughtfully requires additional time. So the continuation of this rulemaking hearing will be held on Tuesday, October 29th, 2024, starting at 11 o'clock a.m. So the same start time in about 2 months' time, October 29. Further, in light of today's robust conversation about the proposed rule changes, it's likely that I will also give individuals an opportunity to provide any additional written comments. So please watch your inboxes for any additional decisions about this rulemaking. Please read through those decisions for any further instructions, and those decisions will likely be setting a timeline for any additional written comments that the Commission may want to consider. That said, if anyone has a written comment that they want to provide at this time, please go ahead. But I will at some point most likely be setting a deadline so that we have them in advance of the next public comment hearing, which will be, as I said, on October 29th. Okay. I will be issuing a written decision memorializing the continuation of this hearing as soon as possible. That then brings to a close this public comment hearing and proceeding number 24R-0306E. I want to again thank everyone for participating, for your helpful and excellent comments. The hearing is now adjourned until October 29th, 2024 at 11 o'clock a.m. Thank you all. Have a good afternoon.